The Supreme Court has recommended the postponement of the Parliamentary Select Committee sessions that were to examine the impeachment motion against the Chief Justice until the court gives its determination on the interpretation of the Constitution. The Supreme Court made this recommendation when the request of the Court of Appeal for an interpretation of the Constitution with regard to several writ applications filed against the impeachment of the Chief Justice were taken up today.
According to the writ applications filed in the Court of Appeal against the impeachment of the Chief Justice under Standing Order 78A, the Parliamentary Select Committee does not have the judicial power to consider such an impeachment motion. The petitions noted that such a committee examining the impeachment motion is a violation of the Constitution. The Court of Appeal noted that the petitions required an interpretation of the Constitution and referred them to the Supreme Court. Thereby, the case was taken up by a three-judge bench comprising of Justices Nimal Gamani Amaratunga, Keshu Pawan and Priyasad Deb. Meanwhile, the petitioners filed a motion requesting court to issue an order preventing the Parliamentary Select Committee from convening tomorrow. The bench pointed out that as only the petitioners were present in court today, the other parties should also be given an opportunity.
Thereafter, notice was issued for the Attorney General to appear before court today, and a court adjourned till 1:30 p.m. When court reconvened, Attorney General Paritha Fernando pointed out that the case had only been referred to the Supreme Court in order to obtain an interpretation of the Constitution. He argued that as a result, the Supreme Court does not have the power to issue a stay order or prevent parliamentary activities. After considering the submissions, the Supreme Court noted that such matters should be resolved in a manner that does not harm the cordial relations between the legislature and the judiciary.
Now, as you know, the Supreme Court procedure for hearing of these things take a while. There are certain steps that have to be taken. So in the exigencies of the present situation, the urgency of the present situation, the ground reality being that tomorrow Her Ladyship, the Chief Justice, has been asked to come in the morning for the first sitting of this committee. We tendered an application to the Lordship of the Supreme Court asking for some order to be made so that tomorrow's hearing will not take place until the matter of the Constitution is sorted out. Having heard both sides, the court was pleased to ask the legislature, the Parliament, to consider the mutual friendship, the mutual coordination that must exist between three organs of government. So in taking that into consideration, their lordships were of the opinion that they should ask the members of the Committee of Parliament who are supposed to embark on this process tomorrow to hold on, not to proceed with the hearing until their lordships settle this matter of the Constitution and until a final word is given on the matter.
The Parliamentary Select Committee, which will consider the impeachment motion against the Chief Justice, comprises of 11 individuals. 7 members of the committee represent the government, while 4 represent the opposition. Minister Anura Priyadarshini Yapa functions as the chairman of the committee, while Minister Nimal Siripala de Silva, Susil Premajanta, Rajitha Senaratne, Dilan Pereira, Bimal Weerawangsa and Deputy Minister Niyamal Pereira make up the government representatives. The Parliamentary Select Committee also consists of UMP parliamentarians John Amaratunga and Lakshman Kiriyalla, TNA Parliamentary Group Leader R. Sambandhan and Bujita Herat of the DNA. Thereby, the committee will consider the 14 changes brought up against the Chief Justice, Dr. Shivani Bandaranaike. The impeachment motion, which was signed by 117 parliamentarians and ministers, was handed over to the Speaker recently. Meanwhile, 2 petitions taken up in the Court of Appeal yesterday requested court to issue an order preventing ministers Bimal Weerawangsa and Rajitha Senaratne from sitting in the Parliamentary Select Committee. The council representing the petitioners noted that the Chief Justice had given an unfavourable ruling against Minister Rajitha's wife and was therefore unfit to be a member of the PSC. The attorneys also pointed out that Minister Bimal Weerawangsa had to withdraw a case from court on several occasions after being taken up before the Supreme Court. They note that as a result of this, the 2 ministers could act in a vindicative manner when carrying out their duties in the Parliamentary Select Committee. The Court of Appeal noted that objections with regard to the ministers being members of the Parliamentary Select Committee can be filed before the committee itself. The Court of Appeal pointed out that the ministers may resign from their positions if such a charge was forwarded.
Now, speaking of news first, Deputy Speaker of Parliament Chandima Weerakudi said that Parliament has not been informed about the recommendations made by the Supreme Court for the Parliamentary Select Committee to defer its probe into the impeachment motion against the Chief Justice.
According to my knowledge, Parliament has not been informed about this. According to the provisions of the Constitution, the Speaker of Parliament appointed a Parliamentary Select Committee to inquire into the issue. This committee in turn should provide their recommendations within a period of 1 month. If there is to be an extension of time, a motion should be passed in Parliament to do this. So this is all I can say for now. I do not know and I cannot say if a recommendation can be issued or if one has already been issued in this regard.
The three-judge Supreme Court bench comprising of Justice Nimal Gamini Amaratunga, K. Sri Pavan and Priyasad Deb went on to say the following regarding the request made by the Court of Appeal on the interpretation of the Constitution. Here are some excerpts.
We have heard the Learned President's Council, who appeared in support of the reference numbers 3, 2012, 4, 2012, 5, 2012, 6, 2012 and 7, 2012, and the Learned Council, who appeared in support of the reference numbers 8, 2012 and 9, 2012. And we have also heard the Honourable Attorney General, who appeared on very short notice. The Court of Appeal, acting in terms of Article 125 of the Constitution, has referred the following question relating to the interpretation of the Constitution.
The Supreme Court statement also states,
Article 125(2) of the Constitution mandates that the question referred to the Supreme Court shall be determined within 2 months of the date of reference. In terms of Rule 64(1) of the Supreme Court Rules of 1978, certain procedural steps have to be followed before a determination is made by this court.
The Supreme Court statement further notes,
This court, whilst reiterating that there has to be a mutual respect and understanding founded upon the rule of law between Parliament and the judiciary for the smooth functioning of both institutions, wishes to recommend for the members of the Select Committee of Parliament that it is prudent to defer the inquiry to be held against the Honourable Chief Justice until this court makes its determination of the question of law referred to by the Court of Appeal. The desirability and paramount importance of acceding to the suggestions made by this court would be based on mutual respect and trust, and as something essential for the safeguarding of the rule of law and the interest of all persons concerned, and the ensuring that justice is not only done, but is manifestly and undoubtedly seen to be done.